number 112544, State of Kansas v. Randy Sturgis.
May it please the Court, Sam Shire of the Kansas Appellate Defender Office, appearing on behalf of the defendant appellant, Randy Sturgis. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. To briefly state the facts for the audience, back in December of 2013, my client, Mr. Sturgis, was charged with being a felon in possession of a firearm. Subsequently, the state added a misdemeanor theft charge. And those charges related back to an incident that occurred back in January of 2013, which was, at least in my view, a staged robbery. When this case went to trial, Mr. Sturgis presented an alibi defense. Notwithstanding that defense, the jury found him guilty as charged. Mr. Sturgis appealed his conviction and sentence. The convictions were upheld. The sentence was vacated, with instructions for the district court to engage in modified categorical analysis to determine what type of prior burglary conviction was used to enhance his sentence. Those orders of the Court of Appeals were petitioned to this court, and that is where we are at today. Unless this court desires otherwise, I'd like to focus argument today on the second and third issues in the petition for review. The second issue has to do with whether prosecutorial errors found by the Court of Appeals were harmless beyond a reasonable doubt. And the third issue is the sentencing issue. So moving on to the second issue, the Court of Appeals determined in this case that the state committed two distinct acts of prosecutorial error during closing argument, but that those errors were harmless beyond a reasonable doubt. And I believe that finding is in error because the errors were quite prejudicial to Mr. Sturgis's defense, and the evidence against Mr. Sturgis's trial, in my view, was quite weak. So starting with the errors, the state first argued during closing that Mr. Sturgis testified that he went to a particular gas station at the time he had an alibi, and that his alibi witnesses testified that he went to another gas station. So what the state was trying to do here was trying to demonstrate that Mr. Sturgis said he went one place and his alibi witnesses said he went another, which would support a finding that the story was being fabricated.
Was it ever established that it was two different stations? I know one was a Phillips 66 and the other was a name. I can't remember the name, but
Presto.
Okay, but why couldn't it be a Presto Phillips 66 station? I mean, why did it have to be two different?
Well, that's possible, Your Honor, and the Court of Appeals points that out in the opinion, but I think that overlooks the significance of the prosecutorial error in this case. Because what the state was trying to do was say, because Mr. Sturgis says he went to this gas station and his alibi witnesses said he went to another gas station, they're not on the same page. So even if Mr. Sturgis had testified that he went to a Presto, it still could have been a Presto Phillips 66. It wouldn't have in any way created some contradiction in his testimony and the testimony of his alibi witnesses. Now, in point of fact, Mr. Sturgis didn't even testify that he went to a Presto. Both he and his alibi witnesses testified that they went to a Phillips 66. So basically, because this was an alibi defense that Mr. Sturgis was presenting at trial, I think it's a really prejudicial error when the state is able to create this discrepancy in alibi testimony and use it against Mr. Sturgis in closing argument, when that argument is not itself factual in nature. With respect to the second incident of prosecutorial error, the state essentially insinuated that Mr. Sturgis was a drug user. And I believe that the Court of Appeals found that there really wasn't any legitimate reason to bring this up in closing unless the state was trying to inflame the passions of the jury. And I would agree with that, and I would analogize this to a violation of KSA 6455. Because essentially what you're getting in here is unsworn evidence that Mr. Sturgis has previously committed crimes. And evidence of that nature can be very prejudicial to a case. A jury could use that as propensity evidence. A jury could return a verdict based on a feeling that a defendant is generally involved in criminal wrongdoing and not hold the state to its beyond reasonable doubt standard.
Would it also be reversible error in your view if what was going on is they were just trying to point out these people are unreliable? Credibility, to impugn credibility rather than to say they've committed other crimes and ought to be locked up?
Well, I don't think that prior drug use can be used to impeach a witness's credibility, with the exception of perception of events.
That's what I mean. That's what I'm getting at. I just think this case is a classic for the reading a cold record being ambiguous about what was going on when these two statements were made. Because I can read what you're arguing was error because it's analogous to 6455 error and say, well, what they're maybe we're trying to do is say, yeah, these people don't know what they're talking about. They're high all the time. But you would say that was still reversible error by the prosecutor.
Yeah, I would say yes, because a 6455 motion was filed in this case, and evidence of prior crimes was generally ruled to be inadmissible. I think if the state wanted to get that in, it should have been run through a 6455 motion. And the other thing I would note is there was really undisputed evidence that Mr. Sturgis' alibi witnesses were drinking. This was a get-together involving alcohol. So to the extent that there's issues of perception going on, I think that would have been covered by just noting that the alibi witnesses in this case were using alcohol. So with that noted, the prejudice of the errors, I think the state's case is really quite weak. Essentially, the only eyewitness that put Mr. Sturgis at this supposed robbery was Carly Bollinger, who I think had major credibility issues, given that she initially told police that she had no idea who the supposed robber in this case was. And you contrast that with Mr. Sturgis' defense, which is 4 alibi witnesses plus his own testimony, and I don't see how it could be plausibly argued that the state has a strong case in this case. So we would ask this court to reverse Mr. Sturgis' convictions for that reason and remand this case for a new trial. Moving on to the sentencing issue.
You're not taking issue with their finding on the other claims?
Oh, yes, that's issue 1. And
okay.
And if this court hasn't...
that on the brief?
I'll rest on that on the brief unless this court has particular questions.
Okay.
I did want to cover the sentencing issue. Okay. I imagine that's probably what this court was more interested in granting review. But essentially, what we have at issue here is the scoring of a third-degree home invasion offense in Michigan, and whether it can be scored as a person or non-person offense. And as I read the Court of Appeals opinion, basically what they held is that in the abstract, this third-degree home invasion offense is not comparable to a Kansas person offense because of the difference in intent elements. Michigan home invasion requires an intent to commit any type of misdemeanor within a dwelling, whereas Kansas requires, in its person burglary statute, an intent to commit a theft, sexually motivated crime, or felony. What the Court of Appeals did after finding that these weren't really comparable statutes was remand back down to the district court for modified categorical analysis to determine what kind of offense Mr. Sturgis actually intended to commit when he committed a third-degree home invasion. And I don't think...
And that is because Kansas includes theft, misdemeanor theft, and misdemeanor sexual battery within its burglary.
Yes.
So it's possible that the facts of the Michigan home invasion could have fit within the elements of burglary of a dwelling in Kansas.
If I understand your question correctly, yes. It's hypothetically possible that the real-world facts underlying Mr. Sturgis's conviction would be a Kansas person burglary.
If there's no way for it to have been, what would be the purpose of the remand?
That I don't see that there is a purpose for the remand, Your Honor, and that's what we're petitioning on. And because in my view, the only thing the modified categorical analysis allows you to do is figure out what statutory crime a defendant was actually convicted of. And so the only thing we can learn is that Mr. Sturgis was convicted under the statutory subsection of entering a dwelling with the intent to commit a misdemeanor therein. We can't figure out, just from the conviction itself, what kind of misdemeanor, because that's not an element of the offense. So that being the case, I don't see what purpose a remand would serve in this case.
What if the charging document or the jury instruction or the conviction specified the type of misdemeanor therein, say a theft? What if it specified that? That isn't really fact-finding. That's going to the documents that a modified categorical approach allows you to look at. I mean, what in that scenario? And I don't know in this case if it specifies that, but wouldn't that be the function of a modified categorical approach, is to explore those court documents that allow you to understand what was the charge and what was the conviction?
Your Honor, my response to that would be that as a matter of constitutional law and as a matter of statutory law, the only thing that matter are the elements of the offense. So even if you have jury instructions that could prove that this was a particular type of offense more narrowly than the actual elements of the offense, it wouldn't matter, because the only thing that matters is the conviction itself. And that's not just a matter of constitutional law. That's how this court has always interpreted KSA 216811E.
It sounds like your argument is effectively, once the statutory analysis is done and these are not comparable offenses, you're done.
That's
right?
Exactly right, Your Honor, yes.
So even if it would be constitutionally permissible under all of this law regarding various approaches, etc., that doesn't mean that the state gets to do it in this case, because they're foreclosed by the statute.
Yes, that's it, Your Honor. And,
that's your argument.
Yeah, and we have a number of constitutional fallbacks, but that's the easiest point A to point B.
In Mathis terminology, the difference between whether the intent was to commit a theft is the difference between an element and a bare fact.
Yes.
The bare fact of theft being the kind of misdemeanor is not an element. The element is intent to commit a misdemeanor of whatever nature. That's Mathis's analysis, right?
That's Mathis's analysis, right, Your Honor. And I'm running low on initial argument. Unless this court has any further questions, I'm prepared to conclude at this time.
Any more questions? Thank you, counsel.
Good morning, Your Honors. Again, my name is Assistant District Attorney Lance Gillette on behalf of the state of Kansas. Unless this court directs otherwise, I will address the issues 2 and 3 as opposing counsel did here today. I'll briefly address issue number 2. In this instance, the state did not cross-petition, obviously, but we were not necessarily prejudiced, although there was a finding of misconduct as to two passing statements in closing argument. The first was in regards to the gas station, and to Justice Johnson's point, I don't think that it was clear. I don't know that there were 2 different locations or if it was just one. I think there was some confusion about that point, and when that was pointed out, the prosecutor moved on, got away from that issue entirely.
Let me ask you though, I'm somewhat concerned about the failure to cross-petition on the finding of error, and there's a little bit of disconnect. I mean, we came in after this case with the new prosecutorial error scenario, but it seems to me that the Court of Appeals did determine it was outside the wide latitude. And without you cross-petitioning on those 2 points, don't we automatically have to go to harmless error?
I don't know that you do, because I think that the catch-22 the state found itself in this case, and has in a number of others, is that in order for us to cross-petition or petition to this court, we need to be an aggrieved party. Here, it was a finding, but we were in no way aggrieved. This
No, you're
conviction-
cross-petitioning. So they've
So-
already
so they-
filed the petition for review, so you know that the possibility of this case coming up to this court is there.
Right.
So why not put in play other errors that you want to argue the Court of Appeals committed in its analysis? That's the problem I'm having, because you don't have to be an aggrieved party once you've
To
got a
cross-petition.
petition for review floating
Right.
by them.
And again, in hindsight, perhaps that's something we should have looked to do. We didn't, and if we do move into harmless error analysis on this case, though, I believe that we made that burden here.
Why don't you do that for me, so that I'm clear as to
harmlessness.
why it's harmless?
Because I think in this instance, as I noted, it was one pass, and I'm specifically referring to the Presto or Phillips 66 comment. This was just, as I mentioned, one passing comment, and there was some confusion. There was an objection to this point, and at that point in time, the defense counsel at trial actually stood up and said in front of the jury that I believe that the record reflected it was a Presto Phillips 66. So this was simply a point of confusion. It was not.
What was the ruling on that objection?
There was no ruling on that objection, Your Honor.
Counsel, under our new Sherman rubric for looking at this, I think Sherman said something to the effect that it doesn't matter whether it was the result of confusion or it was an innocent mistake or it was only a one-time. I mean, none of that matters now when we try to answer that question of harmlessness. So if you could answer Justice Biles' question without referring to what I would describe as the state of mind of the prosecutor, just address its impact on the jury. I think that would be helpful.
All right. And I believe it's difficult to split the two because of the passing nature of the comment, its impact on the jury here would have been absolutely minimal. It was a statement that was corrected by defense counsel. So any potential prejudice that could have arisen was addressed by the objection. Granted, it was not ruled on, but it was a point that was clarified. Where he went during this one moment in time on the night in question was not that much of a significant issue in this case. There was no doubt he left his uncle's home on at least, I believe it was at least 2 occasions. There was testimony he went to get cigarettes, and then we had the evidence that showed that he went down to the Casey's in Derby. So I believe that when you look at the evidence as a whole, and you consider the argument as a whole, that this one-time comment about an issue that everybody was confused about.
But the issue it was mentioned for was credibility.
Correct.
And it doesn't matter where he went, but credibility did matter.
It did. Credibility did matter. And the only thing I can say to that is I think that these particular witnesses had more than enough credibility problems on their own without this one incident coming up. And again, I just think it was an unclear, minuscule fact about a moment in time that had some limited relevance as to the factual scenario here. Again, some relevance potentially as to credibility, but it was something that was addressed.
And that was that after the prosecutor had announced that the defendant is presumed innocent but not presumed credible?
I believe that came later. I believe that came in rebuttal.
Okay.
And just to clarify that, and to that point, myself, because that goes back, I believe, to issue 1. I would urge this court to take the prosecutor's comment, if you're going to address issue 1, to take that in full context. There's a substantial ellipsis in the defense position on appeal as far as issue 1. as well as multiple paragraphs left out before the one passing comment that Your Honor just mentioned. I think it is, when you take that in proper context, it makes sense, and it is not, was not error, was not found to be error, is not error. Then, if I could just touch briefly on the second issue of misconduct while I have some time. I wanted to refer back to in the record, what we had, the prosecutor made the comment, an argument, consider the lonely house on Elda Brown's testimony that she considered the house on Fabrique to be a party house. She stated she believed drug use occurred there. And the prosecutor states, now, by no means am I saying that the defendant used drugs. By no means am I saying that certain other people used drugs. But that's Elda Brown's impression of where Randy would go. The people he was hanging around with. Consider that. And I think, to Justice Byers' point, this is exactly the kind of thing that can come up in a cold record. This is something that, again, this was an issue of, there was a credibility issue here. The prosecutor was not saying that the defendant used drugs. She was not saying that anyone else in particular used drugs. She wasn't even saying that somebody used drugs on the night in question. She was talking about the credibility of the people that defendant hung around with.
But without drug use, there was no implication about credibility.
For
So you
these
really can't
individuals?
escape that. I mean, I don't think that works for you. First of all, it's a briar patch argument. I'm not supposed to tell you people were using drugs, so by no means am I telling you that. I'm just telling you somebody had that impression. I mean, that's a pretty obvious dodge, I think.
Okay.
That even we can see on a cold record.
Right.
But I'm just not understanding how you can divorce the two, the drug use from the implication of drug use having some impact on credibility. Without the implication, there is no impact on credibility, is there not?
For any particular individual, perhaps not. But it's the scenario and the location. And I don't know how clear it ever was who all was at this particular house on Fabrique, and that was part of the problem.
Let me ask that question as a factual matter. Were each of the alibi witnesses supposed to have been present at that address?
At various times,
Okay.
though it's somewhat unclear when and for how long and where and what they saw.
Okay.
Why did it matter what Elder Brown thought about that house?
I'm honestly not sure.
That's that's what I can't explain when I'm looking at this
Yeah.
thing. I mean, why talk about what a witness believed to be true, which may or may, and then saying, well, I'm not saying it's true. I mean, what difference does it make what Elder Brown believed? And if you can't explain that, then it seems to reinforce the Court of Appeals determination, which I don't think we can get to play into because there's a determination of error and you didn't challenge it. So now we're into harmless land, and why would you say that? Why would you put drug use in play?
I think what it was meant to do is because there was some unusual testimony here and an unusual event in that this Elda Brown, she had a connection to both the defendant and the alleged victim of the robbery. They were living in her home. I believe she was an aunt to one or the other. And she sent an email to the Derby Police Department basically saying these things. And that question came up at trial as to why this was going. It was a back and forth issue as to whose story was better. The credibility issue again was central here, and I think both sides were trying to implicate the other in crafting a story. And this was an issue that I don't believe there was any objection to the testimony at the time or the fact that she sent this email to the Derby Police Department. It was, again, I think it was something that was utilized by both sides, particularly in this instance, the defense, to say, well, she's trying to cook this up. So again, I think this was fair comment on the evidence, but again, in fairness to Justice Biles, you're correct. In harmless area and in that arena, this again was something that was in evidence. It was commented to on one point, again, as I set forth in my initial brief in this case, and made very clear, everybody at that house, every potential alibi witness was altered in one form or another, although the night in question it appeared to have all been from alcohol and to various degrees.
But the credibility issue is a little unique in this case, is it not? Because we have the adversary referred to it as a staged holdup, where the girlfriend was the clerk
Right.
at the Casey General Store, and supposedly defendant showed his face so that she knew who it was, and she didn't make the report or didn't snitch on him until they broke up.
Right.
And then she made a report and said he did it. And so, you know, it seems to me that the credibility of both the victim and the defendant were pretty much in play here. Critical to the outcome is what I'm talking about.
A couple things I guess I want to address with that, and I think Your Honor's use of air quotes here, it coincides with how this case is charged from the outset. There's a quote-unquote victim here.
Yeah.
She was told by the defendant before this happened that he was going to come rob her. So the actual victim here is Casey's, and that's why the defendant was only charged with theft. And I think that that is something that can sometimes be forgotten and brushed over as we look at this. The only charge was theft, whether he took something from Casey's without authority, and he did. It was over $700 and 4 cartons of cigarettes. That was shown on video, and yes, she did not initially identify him. If my recollection is correct, though, he became a prime suspect after he was an eyewitness to a suicide at Elder Brown's home, and rather than react as what some folks might expect or even discuss the events of that suicide, he changed clothes out of the clothes that matched the description of the person that committed the theft, and then wanted to discuss with the officers on scene the theft at Casey's. And this is 6 days later, after he's just witnessed a suicide. That's what he wants to talk about. And then it followed from there that further, when he and the girlfriend, the quote-unquote victim, were evicted from another home, a gun and drug paraphernalia was found in their property. And then shortly thereafter, their eviction, I believe, coincided roughly with the breakup. Then Ms. Ballinger cooperated with police and identified the defendant at that time. So while credibility was an issue here, I believe there were other sufficient facts, including the video, including the defendant's own statements, frankly, including his attempt to present an alibi in this case that supported guilt. I've only got a minute and 10 seconds left here, but I welcome any questions as far as the sentencing.
I want to hear what you say about sentencing. Why this doesn't fit right in the middle of Mathis.
Okay, and I think that we have to start here with the fact that Kansas uses comparable. We do not employ an identical or narrow analysis that is required under the Armed Career Criminal Act under federal law. That rule was judicially created by the United States Supreme Court, I believe in Thomas or Thompson, forgive me, under the gun of the clock here, that the Armed Career Criminal Act does not define those offenses specifically set out therein. And therefore, in order to fairly interpret that statute, and at the same time comply with the Sixth Amendment, they came up and decided to utilize a quote-unquote generic offense. And then any offense that was going to trigger the enhancement of the Armed Career Criminal Act had to be identical to or have narrower elements than that generic offense.
And that's a creation of the courts.
Correct.
And Mathis says it was created for 3 reasons: statutory, constitutional, and equitable.
Exactly, and that's what I just explained.
And if it is a constitutional requirement, why wouldn't it impact our determination of comparability?
Because we do not have, because of the 2 differences in test, okay, to require identical or narrower, you have to be able to look at the elements and say, are they identical or narrower? If I go beyond that and start trying to look at facts, then we have a Sixth Amendment problem. If my test is comparable and I can look at the statute itself and say, these elements are comparable, they are sufficiently similar to an offense in Kansas that I can say, you know what, those are comparable. There's no fact finding involved there. There is no Sixth Amendment problem. And that's all that we have to, that's another thing that's important to keep in mind is what we're trying to do here is to not run afoul of the Sixth Amendment. We're not trying to provide some sort of additional protection.
Help me out here, excuse me.
Go ahead.
Help me out, how can you find comparability without looking at the elements of the prior conviction? I don't understand that.
I'm not suggesting that. You do look at the elements and you compare them and you say, are these comparable?
And why couldn't that be done purely as a question of state statutory law?
It absolutely can and it absolutely should be.
And so, how can you, if that's the case, that's essentially what the Court of Appeals did and said these are not comparable. I mean, you would never go look at the underlying case because you're deciding the question of comparability as a question of law, purely from a comparison of the statutory elements.
I think what the Court of Appeals here did was say that they are comparable, but there's a version that they felt there's a version that was comparable and a version of the Michigan offense that's not. And so we have to go back to look and see, is it?
Well, and that goes to my question is why wouldn't or couldn't courts simply decide that as a question of law and say these offenses are comparable or they're not comparable?
They can. They could, and I would ask that this court do so here. And the alternative here...
But aren't you essentially stuck with the Court of Appeals ruling in this case?
Yes.
That in this case, I mean, that they didn't, there is no holding in the Court of Appeals that these are comparable offenses.
Correct. To just explain it a little bit, and it required me to go just slightly outside of the record for this so that this court can understand. This is one of the very first cases I think that we saw, certainly is one of the first in our office that has started to press this issue forward. And at the time, and I think still now, even if what we have here is we have a comparable statute under one subset of facts and a different subset that may not be, we were willing to accept and welcome the remand to have this case come back. And so we could.
But if you're agreeing with me that at least one way to resolve these cases is to decide them as a question of statutory law,
right,
then you don't get a remand. I mean, it sounded like you were agreeing with that conclusion if that's the route that we go.
I think it depends. I think maybe we're differing on what the Court of Appeals said here. Because I think they said that there is a version of the Michigan statute that's comparable, and then there's another version that's not. And it was a remand for us to determine which subsection it came under.
Yeah, well, the reason you get into versions is because you start to inquire into the underlying facts. Because there's only one version of the statute.
I understood the Michigan statute to have two subsections, a subsection A and B, and it was subsection A does
Right.
all.
I don't mean to belabor the point, but
Sure.
the reason that you can pursue that branching tree into the various subsections of the statute, the only way you do that is to look at the underlying case.
You don't have to look at the facts if the elements are separate, and I think that that's what we have here, and what a remand could have been valuable for is under subsection A4A. The question under the Michigan statute is whether somebody broke and entered with the intent to commit a misdemeanor. We don't have to go into looking at the facts of the misdemeanor. The question is, and that's what the Court of Appeals was suggesting that we try to do, but I don't know that we even get to that point.
You're saying look at it to determine which subsection of the statute the defendant was charged under, essentially.
Right. And if it's under A, then we should be fine. As opposed to B, we may not be.
If there were two possible misdemeanors in Michigan, would that be something the jury had to be unanimous about?
And I believe that was something that was addressed and is not clear.
Well, the reason it's important because
Sure.
if you read Mathis,
Mhm.
that they say a bare fact, which is not an element, is something the jury doesn't have to be unanimous about, which would be like our options within a means.
Correct.
And so if Michigan, if the jury could have found a conviction by some of them thinking the intended misdemeanor was unlawful damage to property, another thought it was theft, they wouldn't have to be unanimous, and so therefore, the theft, which is the only way you get to burglary comparability, would not have to have been found unanimous, wouldn't be an element, wouldn't fit within the Apprendi paradigm. Because you're enhancing a sentence based on the sentencing judge deciding it or determining it was theft.
I think there may be three things that I want to say as to this issue. And the first is I don't know that it's clear how Michigan treats it. I think that in Defense 609 letter, they've indicated that there's at least some indication that unanimity may or may not be required. And I'm not clear. That is, again, a question of law, and I would urge this court to consider that. And the second thing that I would say is that what Mathis does is two things. It gives us and reinforces that the modified categorical approach is absolutely appropriate to employ if we have alternative means. What it highlights is that it's not necessarily appropriate where we have methods within a means. It's not appropriate then, because then we do start going to look at facts, because there is no requirement for jury unanimity. And similar to the first case this morning, some of this depends on how the other state treats things. If unanimity is required, then that tends to indicate that it's an element. And that's something that Mathis allows us to do, is to peek at those charging documents, to also look to other state law interpretations to see, is it an element or is it a method within a means? The third thing that I would say is I would return this court to the comparability analysis. And in my final 609 to this court was the Voisin case, where the United States Court of Appeals refused to read in some kind of identical or narrow requirement where it didn't exist. They didn't say that there's a Sixth Amendment problem in the Voisin case. And so I would urge this court to not apply an identical or narrower analysis where it's not needed. And I think that I guess starts to segue into the cases that I know follow me this morning, in that the issue here is, as in the Moore case that follows me, is what was the intent upon entering. That's the only difference between the Michigan statute and the Kansas statute. That difference matters not for criminal history scoring purposes, because in Kansas the question is a dwelling. If it's a dwelling, it's a person felony.
Well, let me ask this, as a matter of statutory interpretation of what's comparable, the word comparable.
Sure.
If you have an act in another jurisdiction that would not be a crime in Kansas, for instance, this is a prime example. If Mr. Sturgis entered into the dwelling with intent to commit unlawful damage to property, that would not be comparable to the burglary statute in Kansas. Any burglary, it would not be the crime of burglary in Kansas, right?
If on those specific facts, it would not be a burglary in Kansas.
So how can we say that that statute is comparable when it includes acts that would not even be a crime?
Because he went into a dwelling with the intent to commit a crime therein. Now, and those are the two things that make a burglary a person felony in Kansas.
No.
It's entering in
No,
Kansas.
not any crime.
Not any
Not
crime.
any crime.
No, I understand.
There's specific crimes, and I think my
Right.
colleague's trying to get you to realize that there are some crimes that a person could intend on entry that would not be crimes in Kansas.
And I do realize that, criminal damage
Okay.
being one that immediately comes to mind. And in that instance, it would probably have been charged as a criminal trespass and a criminal damage. And in that instance, the prior would be scored as a non-person felony.
Well, I'm trying to get to the place of how you can say something's comparable when it's would not be a crime in Kansas. When you can commit acts to be convicted there that would not even be crimes.
And I guess it just comes down to we have to look at the law. And the law here is comparable, and we look at the elements of the offense, and that is the breaking and entering of a dwelling with the intent to commit a misdemeanor, and that's the Michigan law. In Kansas, we have the unlawful entry of a dwelling with the intent to commit a felony, a theft, or sexual battery therein. When I read those as a matter of law, I think it's fair that any judge could look at that and say that's comparable.
So even what we're trying to do here is to not allow a prior offense to be categorized in a certain way that isn't a criminal act under the comparable statute. And it's not. I mean, I think that's the point of all of my colleagues here, is that if you, a burglary in Kansas, if you charged it with the intent to commit a criminal damage to property therein, it wouldn't be a burglary by law. And it would be in Michigan, and that's the problem we have here. And
Yeah, and what it comes down to is if we have to start guessing at facts, then we do sometimes run into a Sixth Amendment problem. But I don't think we have.
But sometimes
to guess.
that's the problem. I mean, we can't get to the underlying facts to determine what that is, and that's pretty much the analysis set forth in Dickey and Mathis, and that's pretty much what we're outlined and following here.
We can't unless, and I would suggest to this court another alternative is we can't unless a defendant waives that option and wants to go and start looking at facts. But I don't think that's the situation here.
Well, to put this in perspective, we're not talking about excluding these convictions from the criminal history score.
Right.
We're simply saying if it's not a comparable crime to a person crime in Kansas, then you score it as a non-person.
That's correct.
And just to be technical, we're not saying that. I mean, that's exactly what the statute says, right?
That is the statute. That's what it tells us to do. So I guess I would just leave in closing with the fact that I believe that the Michigan offense here is comparable, that a comparable test can be defined by this court, and I would ask the court to make that finding here. Just as a final note, I think before I sit down, I know I'm way out of time. I did file a change in custodial status. This issue may end up ultimately being moot in the instant case, but if nothing else, I do appreciate the court's time this morning, and if you have no further questions.
And you just filed it, and the change
did.
was like a year ago.
I did.
So the status changed a year ago.
It
Or
was,
whenever.
June of 2016, I believe.
Right.
Yeah.
Over a year ago.
Correct. If there are no other questions, thank you very much for your time this morning.
Any more questions? Thank you, counsel.
May it please the court. If this court has any particular questions, I'd like to resolve those at this time. If not, I don't have really anything to add that I don't think I covered in my initial argument.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This